A small claims courtroom, quiet except for the shuffle of papers and the occasional cough from the gallery. A woman in a sharp blazer leans toward the microphone, rolls her eyes at the judge, and says, loud enough for the whole room to hear, "Are we really doing this over a mailbox? This is a waste of the court's time, and frankly mine." A few heads turn. The court reporter's fingers pause over her keyboard for just a moment. The judge doesn't respond right away. She simply sets down her pen and looks up, slow and deliberate, in a way that makes the entire room go quiet. Not angry, not rushed, just still, in the particular way that tends to make people realize they've said something they can't take back. What that woman doesn't know yet is that in about 4 minutes, this waste of time is going to end with her name read into a formal contempt citation in the very courtroom she just insulted. How does a dispute over something as small as a mailbox end up here? Let's go back 3 weeks to the moment someone decided a half-inch mattered enough to escalate it this far. Samuel Reyes had lived on his quiet suburban street for 5 years, in a home with an HOA-approved mailbox post he'd installed himself, following the exact design and height specifications listed in the community handbook down to the inch. He'd even kept the receipt for the materials and a photo of the finished post, mostly out of habit. Brenda Kowalski, a longtime HOA board member who'd served on and off for nearly a decade, decided his post was half an inch too tall, a measurement she'd taken herself, with no official inspection, no documentation, and no basis beyond her own eyeballing of it from across the street one afternoon while walking her dog. She filed a formal violation anyway, and when Samuel asked to see her actual measurement on record, she brushed him off entirely, insisting her word as a board member should be enough on its own. "It's clearly too tall," Brenda said, arms crossed in his driveway, sunglasses pushed up into her hair. "I don't need a tape measure to see that." "The handbook lists a specific height," Samuel said calmly. "Mine matches it. I measured it myself when I installed it, and I still have the receipt." "I've been on this board 8 years," Brenda said. "I know what's compliant when I see it. I don't need paperwork to tell me that." "I'd just like something in writing," Samuel said. "That seems fair, given I have documentation and you don't." Brenda's expression tightened. "This isn't a negotiation, Samuel. If someone confronted you this confidently over something, you'd already double-checked yourself. Would you hold your ground the way Samuel did, or would the certainty in their voice start to make you second-guess something you knew was correct?" Samuel simply thanked her and went back inside. Brenda, unsatisfied, was already planning her next move before she'd even reached the sidewalk. Within days, Samuel received a formal HOA fine notice, $150, with a threat of daily increases if the post wasn't lowered. He called the management office, who confirmed there was no inspection on file, and that his post, by their own official measurement taken that same afternoon, was fully compliant with the handbook specifications. Brenda didn't accept that either. She kept pushing the fine through the board's internal system anyway, eventually filing to have it entered as a formal lien against his property in small claims court, a step that required an actual judge to review the evidence, something Brenda seemed strangely unbothered by, given she had none. Does that sound like enforcing a rule, or does that sound like someone unwilling to accept being wrong, no matter how many people along the way told her so? Samuel, calm as ever, gathered his own measurements, photos, and the management office's written confirmation, and prepared for the hearing. For a couple of weeks, nothing moved. The hearing date sat quietly on the calendar, and Samuel went back to his normal routine, hopeful the paperwork alone might settle things before anyone needed to appear in person. It didn't. The court date arrived anyway, and so did Brenda, fully convinced she'd win without any real evidence at all. In the courtroom, Judge Whitmore reviewed the filing calmly, asking Brenda directly for her documentation supporting the violation. "I measured it myself," Brenda said, waving a hand. "I don't need a tape measure on file to know what I saw." "This court does need documentation," Judge Whitmore said evenly. "Do you have any at all? Have you ever seen someone show up to a formal hearing with nothing but their own opinion as evidence?" Samuel calmly presented his measurements, time-stamped photos, and the HOA management office's written confirmation of compliance. Judge Whitmore reviewed each page carefully, occasionally glancing up at Brenda. "The management office's own inspection contradicts your complaint entirely," The judge said to Brenda, "Do you have anything to add? Any documentation at all?" Brenda shifted in her seat. "I don't need a piece of paper to tell me what I already know." That's when Brenda, visibly frustrated, rolled her eyes and delivered the line from the hook, dismissing the whole hearing as a waste of time, in front of the judge, on the record, in a courtroom full of people waiting for their own cases to be heard. Judge Whitmore set down her pen. "This court takes its time seriously, and so will you. Given your comment and the complete absence of evidence supporting this claim, I'm dismissing the case and entering a formal note of contempt for your conduct today." Brenda's face went pale. "You're joking." "I'm not," the judge said simply. Did Brenda expect that outcome when she rolled her eyes at a judge? Almost certainly not. The lien was dismissed. The HOA board quietly reviewed Brenda's pattern of unilateral complaints in the weeks that followed, and Samuel's mailbox post stayed exactly where it had always been, fully compliant, exactly as the handbook required. Samuel never gloated about it. He just wanted the matter closed fairly, and in the end it was. This was never really about a mailbox. It was about what happens when someone assumes their opinion outweighs actual evidence, even in a room built entirely around evidence. If you enjoyed this one, hit like and subscribe for more real HOA and courtroom karma stories every week. Have you ever seen someone talk their way into trouble with a judge or an officer? Tell us in the comments. We read every one.